the original court, and the original court is defining the rules to mean the trial court. Like this one, shall submit the reference in terms of Form 2 of the schedule to these regulations, stating the specific questions or issues to be answered or resolved by the court. Mr. Chairman and members, the Form 2 of the reference in paragraph 1 requires that this court is of opinion that a substantial question of law as to the interpretation of the Constitution has arisen in the proceedings. So it is not true, as stated by Senior Counsel Mr. Rukwago, that court's hands are tied. It's court to form an opinion, therefore it has a discretion to determine whether indeed it is all this that matters that require constitutional interpretation have arisen in these proceedings. We shall approach the issues raised, and our take is to begin with issue number 3 regarding the impartiality of this court. We note that on the 13th January 25, names of members of this court were requested and read to their accused. They were asked and had no objection to any member, and that was in pursuance to the regulations. In that regard, we would say that an issue of impartiality does not arise in these proceedings because the accused have not objected to any member. On this same provision, Regulation 49 of the UPDF Rules of Procedure Regulations requires the opinion of each member. As a way of handing down verdicts. So a challenge to the impartiality of court should go to the opinion holder, and since names were disclosed, that would be the approach. And this is also the approach in civil courts. I'm glad Honorable Martha Karua told us she has been a judicial officer, and those are the principles of civil court, where you request the judicial officer to excuse themselves. Regarding issue number 1, it deals with whether the offense under offenses relating to security, section 128, F of the UPDF Act defines the offense. Mr. Karibala says that it does not define the offense, together with Mr. Panga, and their view is that because it says the person who omits or does an act. When you cross-reference with other laws, an offense can be constituted by an omission, it can also be constituted by an act. Even in the penal code, an unlawful act or an unlawful omission can constitute an offense. there is also a requirement in the offense that the intent must be to reduce the security of the defense forces. Those are matters once alleged that are supposed to be the subject of evidence, and the burden is on the state. But at the moment, this issue is premature. It is determined with evidence, and this court can decide that matter. There is also an issue regarding whether the trial of civilians in general court martial is consistent with decisions of civil courts in earlier cases. And one of the cases cited is the case of Honorable Michael Kalvinuka versus the Attorney General. Most other cases cited, including retired Captain Amon Bialgala and Semuju Abduminana, were referring to that decision of the Constitutional Court. But the decision is pending before the Supreme Court, and the orders and declarations made in that decision were stayed. So it would not be an authority that determines the position. We would rely on other authorities. The other authorities included the case of Khadija Namgeba versus Attorney General, Civil Appeal number 424, where they said the provisions of section 119, which is now 117 of the Immediate Act, is proper. And charges can be maintained under that provision. There is also an issue number 7, whether the General Court Martial has jurisdiction to deal with cases under the Firearms Act. The UPDF Act defines a service offense to include offenses under the Act and those under any other act for the time being in force committed by a person who is subject to military law. And the Supreme Court has pronounced on this in Attorney General versus Uganda versus Swati. At page 10, and in that case, with a unanimous decision of the Supreme Court arising from the Constitutional Appeal, they only required that for an offense under an act other than the UPDF Act to be within the jurisdiction of the General Court Martial, it must have been committed by a person subject to military law. And what they required was to allege and show that the accused persons committed either of the two offenses where they were subject to military law. That is the link they required. And the applicants have not shown that that link is not in the charge sheet, and it is the burden of them to show that there is no link. is not alleged that these people were subject to such law. We also wish to point out that there are procedural safeguards for the trial of persons before the court, including presumption of innocence, burden of proof, and these are matters for a trial court. These are not matters that require constitutional interpretation. That I hand over to my colleagues to continue.
I would like to back up the submissions of my examples. I'll begin by quoting Article 152, Clause 4 of the Constitution. It says that the Supreme Court will, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. The Supreme Court has severally decided that these courts have jurisdiction to try the accused persons. And my colleagues on the other side repeatedly citing the decisions of the Constitutional Court would be in contravention of that specific article. And then I will reply to the other general issues, specifically Regulation 63, Regulation 2, and Regulation 69. Lord Chairman, the General Court Martial operates under the framework of the EPDF Act, which ensures its independence. The Act provides a clear separation between the administrative functions of the High Command and the judicial functions of the General Court Martial. Rather, I refer you to Section 14 of the EPDF Act, Cap 330, and Section 195, so establishes the General Court Martial. While the High Command may oversee the general military administration, it does not interfere with the decision-making process of the General Court Martial. Members of this court, including its chairman, are carefully selected and sworn to administer justice without fear or prejudice. Whether this is under Regulation 14 of the Economic Defense Forces Regulations. They are guided by the principles of fairness and impartiality enshrined in the Constitution, Article 28, and the EPDF Act. The presence of the legal officers and adherence to established legal procedures further guarantees impartiality of the proceedings. This court has autonomy in its decision-making process. It conducts trials based on evidence, law, and legal principles, not directives from the High Command. The decisions rendered, furthermore, the decisions rendered are subject to appeal and review by superior courts. By superior courts, I mean the Court Martial Appeal Court. This is provided under Section 225 of the EPDF Act. The relationship between the GCM and the High Command is administrative, not judicial. The High Command's involvement ensures logistical and institutional support for the court martial, but does not extend to influencing judicial outcomes. Now, concerning Regulation 63, Regulation 2, it's very clear the role of the judge advocate is to advise the court on matters law. If the court disagrees with the decision, they shall record in the proceedings in its reasons. It does not mean that they are entirely binding, as one of the colleagues on the other side alluded to. May Lord, I give way to my other colleague to submit. Let me know.
Chairman, board members, straight over to the question that was framed by my colleagues, especially question 6 on the arrest in issue and 5 of former 2, which is person that is can retired. That is arrested and charged beg today. Chairman, and board members, the ruling that was rendered by this court today morning settled that. And in that ruling, the court clearly pronounced itself as far as the arrangement that is between the 2 countries, that is Kenya and Uganda. And my chairman, that arrangement is backed by the law. It's backed by the East African Community Treaty, which Uganda is a party. Not only being a party, but it also domesticated that treaty. And the same thing, domestication, was done by our neighbors, that is Kenya, also domesticated that treaty. So, my chairman, under that treaty, specifically under Article 124, that addresses the protocol of peace on peace and security. And the article outlines the commitment of partner states to cooperate on issues related to peace and security. And my chairman to put into motion or to put into practice that cooperation. That's when we see the coming up of that memorandum of understanding for the 2 states cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to this court, the authority that my brother and senior colleague, Council Pago, alluded to, the one of Amar, Awad, Umar, and 10 others. And my Lord Chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. And if I may, on page 70, page 71 of that judgment, the chairman, under paragraph 30, if I may read verbatim, states that we also observe that the East African Community Treaty was investigated in Kenya, Tanzania, and Uganda. The Uganda Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005. The East African Community Act amendment instrument 2005. It came into force apologies, I think I misplaced that paper. But the argument I'm making is that there indeed exists an arrangement between the two states, the two partner states, that is Kenya and Uganda. This one was confirmed by authority that was clearly and well cited by my senior colleague, though with blood interpretation from his side. But be as it may, my Lord Chairman and honorable board members, we submit that indeed the laws were followed. In other words, in the absence of the extradition treaty between Uganda and Kenya, this law applied squarely in both countries. My Chairman also, and that one would not really need a reference to that lead, otherwise it would be a waste of God's time. But Chairman, on the other issue, which issue 2, and my senior colleague earlier looked it and submitted it, but maybe to add something that is important. We really read all the authorities that were provided to us by our colleagues, and good things are cut across in all those authorities. And my colleague talked about it. There is a recent ruling. This one you may not need to refer to the Constitutional Court. And that ruling was very clear, staying the execution of the Kabazibuka case findings. It is as plain as that. You don't need to refer to court that interpret this or try civilians. It will be absurd, very absurd. And our chairman, further on that, we also confirmed that indeed the decision, the authority that was cited by Steel Council Tukwago, one of Abdul Semuju, aka Nan, the issues that had been raised in Kabazibuka case were the same issues that were raised in Nan. He can testify, he argued it. So, my chairman, it would be the defeat of justice. And not only that, but also wasting court study. Now, also apply to stay the execution of Menara. Though there has been an appeal, we are aware, and the Council Park is also aware that there has been an appeal against the decision of the Constitutional Court. We are yet to know the hearing dates. But, Madam Chairman, we submit that we base the trial of civilians in this court on the decision for the ruling staying execution, the decision of Kabazinduka. And therefore, in this matter, none cannot really suffice.
As you're watching Extreme Media Yogi.
As I conclude, Madam Chairman, and board members, I would also like to add something on the question of Impartiality that my colleague talked about. Whether the General Court Martial can be impartial on adjudicating matters before it, and the reference was made to 28:1. Madam Chairman, my colleague addressed that, but to add something, under section 207 of the APDF Act, where rules of procedure and evidence that apply to civil courts can as well be applied to general court martial. That is in the law. And Madam Chairman, that goes back to the supremacy of the Constitution. Now, under that Constitution, it provides clearly two things: the impartiality of courts. So it's out of that law that is now 207, it applies to general court martial. So what my colleague said, and that article under 128(1) of the Constitution and 2. So impartiality really it is there. This code is impartial. And Madam Chairman, lastly, I wish to also add on what my colleague said, and that is on the procedure, on how you refer a question for interpretation of the Constitution. Madam Chairman, that one was settled by a constitutional court in Ismail Selko against Kampala City Council. And Justice Wampu's then was very clear, extremely clear. He stated that the petition can just that with the necessary modification reference must show on the face of it that interpretation of a provision of the Constitution is required. But Chairman, what we saw today and the framing of questions was an appeal in this case. An appeal in this case. The questions, the way they are framed, we would actually say that the counsel for the accused persons under the Commercial Appeal Court rules through appeal against the ruling that was rendered today morning. Other than casting a net, let us see what comes out of the lake. The court does not operate like that, Madam Chairman, and I pray that you should not allow that to happen in this court. Madam Chairman, that was also emphasized recently by the Constitutional Court reference number 31 of 2010. That is Uganda against Francis Atugonza. And court stated that constitutional reference by the court that is determining the cause or a party to the proceedings who request the court, and this goes back to what my colleague, Senior Council Kalibara stated that the courts, the hands of court are tied, quite absurd. They are not. That's why you're here. No, Chairman, that statement itself, it simply puts a constitutional court into a position of applicability of the law, of the rules, which I disagree with my colleague. The constitutional court can apply the law in other cases, but as far as constitutional reference is concerned, it's basically interpretation, not applicability. Not applicability. Applicability is with the authority of court. Now, whether the court, I'm not saying this court, whether the court, any court, applies the law neutrally, that is a different matter. And there are channels. You appeal. You appeal. That's what he told me. Now, and lastly, my Chairman, we pray that
Guys, I'm liking. I'm thank you, Nathan.
unless the law has since changed, but my Chairman, lastly, we pray that from my side, because my senior colleague is going to give it a final push, we pray that you really increase it us on the law, and especially where you are satisfied with the decision to the ruling of court